Hi everybody, Ahmad Sadiq from Land Trust Title of Central Florida. Let's talk title. Today I wanted to spend a little bit of time talking about a document that we see very frequently that's used in real estate transactions, and that's the power of attorney. Now, not only is a power of attorney document an effective tool to use in the middle of a real estate transaction, it's also a really important estate planning tool and can be beneficial in a lot of different circumstances. Now, the power of attorney essentially is a document where the primary power holder is going to give power to an agent to act on their behalf. And so ultimately what that means is the document is created saying, I am giving power to this particular person to do these particular activities that are outlined in the power of attorney document. And that document is then going to be notarized and witnessed by two different witnesses. Now, there are a couple of different circumstances in which we need to be careful in terms of how the power of attorney document is created. So first and foremost is we want to make sure that the power of attorney document actually contains information that's going to allow the agent to act on behalf of the principal. And so what I mean by that is what we see often in our real estate transactions is when the power of attorney document is created, the document should say specifically that the agent has the authority to sell and convey property on behalf of the principal. And if the language is not in here, title companies, attorneys, underwriters are not going to be able to use that power of attorney document in an effort to help with the real estate transaction and with the real estate closing. Then, in addition to that, we want to make sure that it's understood by the principal that the power of attorney document is not a springing document. And so what we mean by that is that the power of attorney document, once it's created, effectively notarized, and executed by all parties, doesn't then become effective at some point in the future when some event happens. What it means is that the power of attorney document is effective at the time the document is executed, and the agent can then act in the place of the principal as soon as that document is executed. So what that means for us is that we need to be sure when, as an attorney, we're helping our clients create a power of attorney document that they're completely comfortable and completely trust the person that they're going to be utilizing as an agent. And we want to make sure that the powers that are outlined in that power of attorney document are powers that that principal actually wants to give to the agent, and that they understand that that power is effective at the time the document is created. Now, there are a few avenues that the principal can take to remove those powers. So during the course of the principal's life, principal can record a document in public records indicating that any power of attorneys that have been created are now ineffective and that power has been withdrawn from them. Or they can create another power of attorney document for a different person, but it's important that language in that power of attorney document state that any previous power of attorneys that have been created are now ineffective as of the signing of that new power of attorney document. So we want to make sure as attorneys, as title companies, that the documents that we're utilizing to help with closings are not only properly executed, but that the powers that are defined within that document are going to be effective to help the principal conduct the business that they want to have the agent allowed to do in their stead. And we want to make sure that everything is effective so that we can get the transaction closed at the closing table. Thank you guys. See you next time.